Welcome to The Heart of the Matter, a podcast that covers legal developments from around the world. I'm your host, Stephen Lai. This podcast is brought to you by Conventus Law. In this episode, we'll be looking at digital intermediaries and how new regulations have redefined their roles and responsibilities. Joining me in this episode is Arun Prabhu, partner and head of technology and telecom at Indian-based law firm Siro Amachad Mangaudas. Before getting to the heart of the matter, a message from our sponsor who generously supports this podcast.
Ashford Benjamin was founded with the belief that search firms should offer a better service to clients and candidates. This means taking the time to provide a genuine partnership, understanding our clients' and candidates' needs, and proactively advising on the best course of action, utilizing the decades of experience in our industry specialisms, including risk, compliance, business and legal recruitment consultancy, located in central Hong Kong, serving Asia Pacific.
Welcome back to the last episode, Arun.
Thanks, Stephen. It's great to continue this conversation.
Great to have you back. Now, we've covered a lot in the last two episodes. The last episode we'll be covering intermediaries, how they affected in relation to all these regulatory reforms and legislation reforms. Now, Arun, over the last couple of years, there seems to be a lot of renewed focus on regulating intermediaries and refining their roles and responsibilities. Now, in October last year, MEITY amended information technology intermediary guidelines and digital media ethics code rules, known as the IT rules. What are your views on this?
It's adding on to an existing structure. Intermediaries, as defined under the Information Technology Act, essentially were people who got a safe harbor, right? They were people who were essentially whom we would recognize as the people who provide the pipes in a system. Email providers, telecom companies, even data center providers for that matter, who fundamentally provide underlying infrastructure over which communication is carried. And as we know from the DMCA and jurisdictions elsewhere, there's a need of a safe harbor for them just because they don't actually originate this information, they're just passing it along. And so there was a safe harbor for it, and there were some rules which were applicable to them. And they sort of meandered in the corner of the internet, weren't really strongly enforced, and they weren't the focus of much regulatory action or indeed litigation, except in the context of things like safe harbor protection for IP infringement or infringing content and pornographic content and so on and so forth. That's when people would sort of go back and say, hey, I'm an intermediary, I do what these rules require me to do, and so on. In 2021, this entire framework was completely refreshed. And this actually was divided into a three-part framework. The first part of it just applied to intermediaries simpliciter. The second part of it applied to significant social media intermediaries. And then the third part of it applied to online content providers, which were basically the providers of streaming services. So fundamentally, they took this existing regime and sort of built on top of it to cover these diverse sets of entities. And in addition, they also covered news publishers, so people who published online news. This was the 2021 iteration of it, and parts of that were met with significant concern because it talked about, for instance, for intermediaries, it talked about obligations such as tracing the origins of communication. For online content providers, it required them to do classification in terms of content. And for people who were engaged in providing news and current affairs content, basically news publishers and news aggregators, they required them to comply with journalistic norms. Now, parts of this have been challenged before various courts in India. Parts of them still remain sub judice. Some of these challenges have been upheld. Courts have fundamentally said, don't take coercive action against people until we resolve this and so on. What happened in 2022 is that this framework was actually built on even further. India has operated for long under the actual knowledge standard. Now, actual knowledge basically says that unless a court or the government tells you that a piece of information is illegal, you as an intermediary cannot are not assumed to know that it's illegal and therefore don't have an obligation to take down that information, right? So it created a clear standard based on which an intermediary would say, hey, this is okay and this is not okay. And then it was very straightforward. You either went and got a court order to take down information, or the government passed an order under a very specific framework, which included an appeal and so on and so forth. That has significantly been diluted under this 2022 norms. So 2022 basically creates an obligation for an intermediary to take reasonable efforts not to allow users to do certain things. It also creates more positive obligations on intermediaries and creates another structure called a grievance addressal committee. So everywhere, intermediaries are required to provide grievance redressal to their users. And when users aren't happy, their usual approach used to be to go to courts. Now, a grievance appellate committee, which by the way has been notified a couple of days ago, was created. 3 committees have been created. So users will have the ability to say, hey, my intermediary is not either taking down this content or has taken down my content for reasons which I don't agree with. I've written to them, they've not given me a response. Now I'm going to go to this grievance appellate committee, effectively creating a sort of superior super user level body for intermediaries. So in addition to that, of course, there are new rules which have come around specific types of intermediaries, which are called gaming intermediaries. So if you are in the business of providing online games, there are specific rules which are now applicable to you. And lastly, there's also been most recently an obligation which requires them to take down actions which are treated as fake news by the certain government website. So there's a government website or a set of government websites which has been prescribed. If something is listed as fake news, then the intermediary has to take it down. So just fundamentally, intermediaries are finding this an increasingly complex regulated environment in which to operate. And we only see this becoming sharper once the Digital India Act is enacted, because the legislative framework under which intermediaries are regulated will be strengthened significantly. So presumably the obligations will be even more sharper and tangible.
The original purpose of intermediary is almost you're just basically passing on. You're like a middleman, right? You're just basically doing whatever the original party is telling you to do, and you just do it. And it was much more simple back in the day, I guess. So I guess it makes sense for these changes to happen now. But do the intermediaries have the right to be concerned about this? I mean, it sounds like there's suddenly a lot thrown at them from nothing.
Well, yes, but like you said very correctly, I think the world has changed, right? If I am to apply the classic test of an intermediary, which is someone who passes on information in exactly the manner as they receive it without doing any actions on it, there'd be very few people who meet that test, right? Except maybe people who provide dumb copper cables. Pretty much everyone else in some form selects information, sorts it, arranges it, filters out spam, provides various services in relation to information. And of course, if you're looking at intermediaries like e-commerce, they obviously prioritize search results. They prioritize outputs which come in. If you're looking at social media, then it's even more, because you prioritize feeds and prioritize streams. So to some degree, there's control over what you choose to see. And then, of course, as online content providers or news publishers, you often originate parts of the content, right? So, a diverse set of entities is sought to be covered under these legislations, all of which are sort of squeezing through that intermediary keyhole. So yes, while some of them have, reason to be concerned to some degree, I think all of them should prepare for an increasing amount of regulatory focus almost globally in the space.
Interesting. Well, thank you for that. Now, while we're on this topic, I understand the Indian government has also released a draft amendment to the IT rules to regulate online games. Online games are surely not intermediaries. I mean, they are the original source, right? So I signed up to an online game. I'm directly giving the games provider my data, and they're not. Maybe you can help me out here, because I don't really understand how they're intermediaries.
Well, it's interesting you say that, because I think there needs to be a distinction made between the content, which is the pre-existing content, and the content that's created. Now, I would argue that a game provider provides you a framework, right, which is the map and potentially some skins and the tools and so on, and then you go in there and you use that to create content on that map. So there's a fundamental difference between gameplay played between leading teams in the world cyber games and a game that you and I would play, for instance, right? To use a crude analogy, the game provider provides the chessboard, Whereas I, depending on Magnus, whether Magnus Carlsen is playing someone else, I play the game, right? And in respect of the actual gameplay, which is where all of the value is and all of the visibility is, that's actually pure intermediary activity. In terms of communication between players, that's pure intermediary activity. So I actually think that shoe fits quite well. They are intermediaries to my mind. There are aspects of the content in which they may not be intermediaries. So, for instance, like pre-written clips and so on and so forth. But again, if we're talking about online real money gaming, which is really what this is focused on, that sort of pre-recorded consent is actually fairly thin. It's not really front and center. So, to my mind, intermediary is a decent fit for it. At the same time, this is a sector which is very interestingly regulated. Like you mentioned earlier, state regulation and central gaming is a state subject in India, and every state, especially in the southern states, have tried to significantly restrict this. And the consequences for gaming, of course, are covered under gambling. So there have been FIRs against leading, the promoters of leading gaming companies and so on and so forth. The FIRs being sort of like first information reports, which lead to arrests. So these are, there have been serious criminal consequences for people. So the existence of a central framework, right, at some level has been a long-standing cry. So the regulation of these as intermediaries is a very, very interesting approach taken.
Well, thank you for clearing that up. And just for the record, if I was to ever play Magnus Carlsen, I reckon I'll last about 10 seconds. And then I'll be.
But it would make for great gameplay, right? But
yeah.
On the other hand, if you and I played, we'd probably take far longer, but far fewer people would look at it.
MEITY are looking at this, right? And so how are they going to do this exactly? How are they going to do these with the proposed amendments?
Yeah, so it's a bit of a carrot and stick, right? The proposed amendments basically say, it's actually a very, very interesting, innovative approach they've taken. So they've said, here are some hard rules, right? So you need to have terms and conditions, you need to have privacy, you need to put in certain basic things to prevent people from you need to have a random number generator certification, no bot certificate, basics rules to make sure that there's no hanky-panky, right? That's hard-coded in the rules. But then there's a second layer, which is actually enforced by what are called self-regulatory organizations, which basically say, you guys, as the industry, go form an organization, make sure it meets certain criteria, come to us for a registration. If we like what we see, we'll register you. And once we register you, that organization gets to look at your game formats and say, hey, this is a valid format, this is not a valid format, right? And once that game format is registered, the fact that it's registered then gets to be put up on the website, it gets to be put up on advertising, it gets to be put up on Play stores and so on and so forth. So over time, you're creating economic incentive for someone to sort of go in and register their games.
Great. Well, with that, that concludes the episode and the series. And I want to thank you again. It's been really good insight, and thank you for agreeing to come on to the show.
Thank you so much. I've enjoyed these conversations very much, Steve. Thank you so much, and I look forward to speaking with you again.
Me too. Thank you. Thank you, listeners, for listening. I look forward to talking to you on our next series.